Mr. Schurr, it is alleged that on April 4, 2022, that you did with the intent to kill or to do great bodily harm, or to act in wanton willful disregard of the likelihood that the natural tendency of said act would cause death or great bodily harm, kill and murder a Mr. Patrick Lyoya, and that the act was committed without premeditation or deliberation. That, if true, would constitute the felony offense of murder in the second degree. It is punishable by a maximum of life incarceration or any term of years. Do you understand the charge and the maximum penalty associated with the charge?
Yes, Your Honor.
And you had a chance to talk to one of your attorneys, Mr. Dodge, one of the other attorneys, about your rights?
As of today, I have not.
All right, have you reviewed the felony advice of rights form?
No.
Mr. Dodge, have you had a chance to talk to your client about his rights?
No, Your Honor, because of the issues here with where Mr. Schurr is housed, we have not been provided those yet or had the opportunity. So it may be wise for Your Honor to go ahead and review those
Oh.
in court.
Very good. All right, Mr. Dodge, number one, you have the right to remain silent. You have the right to be presumed innocent until proven guilty. You have the right to a trial. And at the trial, you have the right, you have a number of procedural rights. You have the right to call witnesses to testify on your behalf. You have the right to cross-examine witnesses that are called against you. You have the right to ask the court to compel witnesses to come in and testify on your behalf. Are you familiar with the rights that you would have at a trial?
Yes, Your Honor.
All right. Very good. And Mr. Dodge, are you satisfied that your client understands his procedural rights at this point?
Yes, I do.
Very good. So the first question for the court is indeed whether the defendant is eligible to be released pre-trial at all, whether the defendant is bailable. Based on the factors here, particularly the fact that the defendant did surrender or turn himself in, has retained counsel, that defendant has no criminal history to speak of, the court can make the general finding that indeed the defendant at this point in time is bailable. And I will make that determination. The next question then becomes whether, or the terms and circumstances under which the defendant can be released. Our court rules require that the court generally presume a personal recognizance bond unless the court finds that personal recognizance bond won't reasonably ensure the appearance of the defendant or that release on personal recognizance presents a danger to the public. Again, the court weighs heavily on the fact that the defendant did turn himself in. And at this point, there is no demonstration of non-compliance. However, the nature of a particular charge itself is another factor that the court considers. And there are certain charges, there are capital offenses, that by the sheer nature that is the charge that the patient is facing, elevates the risk, elevates pretrial risk. And I think the court does have to take that into account here. And so while certainly it weighs heavily on the court that the defendant has turned himself in, is in compliance, has no criminal history, those things weigh heavily, but the court also has to consider the charge. And so I don't think that a personal recognizance bond is appropriate under those circumstances. What I do find is that a cash surety bond is necessary, and I will set that bond amount $100,000 cash surety. That will also be subject to a number of special conditions that will be imposed as a condition of pretrial release. Will order the defendant not purchase or possess any firearms or dangerous weapons while the case is pending. The defendant report to court services and remain under their supervision while the case is pending. The defendant not use any intoxicating liquors, marijuana, or illegal drugs. Undergo substance abuse assessment if that is directed by court services, if that is deemed necessary, and not engage in any assaultive, threatening, or intimidating behavior. Do you understand all those requirements, Mr. Schurr?
Yes, Your Honor.
All right. Mr. Dodge, anything further from your perspective?
No, Your Honor, thank you very much.
All right. All right, good luck with everything, and again, before the record, and so everyone has it down, the probable cause conference will take place on June 21, 2022 at 9:30 a.m., and preliminary examination, if necessary, will be conducted June 28, 2022 at 1:30 p.m. All right, take care, everyone. Thank you.